Corporate Transparency Act is probably the most significant piece of federal legislation affecting business in over 100 years, basically since the U.S. security laws were enacted in the 1930s. The law went into effect in January, and it represents a major shift in how companies are viewed by the federal government.
Today on Law Next, the new beneficial ownership reporting requirement and how legal tech can help companies comply. The arrival of 2024 brought a new reporting requirement for more than 32 million smaller companies in the United States. The new requirement, which came about as part of the Federal Corporate Transparency Act of 2021, means that many companies will now have to report information about their beneficial owners, the individuals who ultimately control the company. With new requirements for companies to collect, document, and submit previously unreported information, and with many companies confused about what the law means for them, legal tech companies are stepping up to help, with new products specifically designed to facilitate understanding and compliance. One company that is taking the lead on this is Wolters Kluwer. It has launched a beneficial ownership platform for legal compliance and accounting professionals, and it has enhanced its Legisway platform for corporate legal departments with new beneficial ownership functionality. Today we'll dig into this new law and its requirements and hear about how technology is helping companies comply. To do all that, I am joined by three executives from Wolters Kluwer: Ross Aronowitz, Vice President, Law Firm Segment Leader at CT Corporation; Ken Crutchfield, Vice President and General Manager of Legal Markets at Wolters Kluwer Legal and Regulatory US; and Kathy Rowe, Senior Vice President and Segment Leader, U.S. Professional Market, Tax and Accounting, North America. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. One further note about this week's episode. Last week, after we recorded this conversation, a federal court in Alabama ruled that the Corporate Transparency Act is unconstitutional. For now, the impact of the ruling is narrow. It's limited to the two plaintiffs who filed the lawsuit, and the federal government has said it will file an appeal. Meanwhile, it is expected that the government will continue to enforce the new beneficial ownership rules. Before we get to all that, please take this moment to learn about the sponsors whose generosity supports this podcast. As a lawyer, providing excellent client service is always top of mind. But how do you balance that with managing your firm's internal processes? Practice Panther is the all-in-one solution that streamlines your workflows, giving you more time to focus on your clients' matters. With its innovative case management features, automated billing, secure document storage, and custom report generation, you'll never lose track of your cases. Join the tens of thousands of law firms that trust Practice Panther to manage their practice. Visit us at practicepanther.com to learn more. Now, on to today's conversation. Welcome to all of you to Law Next. Pleasure to have you here today. Before we get into the conversation, since there are so many of us on this recording today, let me go around and have each of you introduce yourself and tell us a little bit about what you do at Wolters Kluwer. And Ken Crutchfield, let me start with you.
Hey, Bob. Great to see you again. I manage the legal markets business within the legal and regulatory division. That includes Vital Law, the RB Source platform for legal research for law firms in particular. And I also manage the Legisway product in the U.S., which is an all-in-one legal software solution for corporate legal departments.
Thanks, Ken. And Kathy Rowe, how about you?
Great to chat with you here today, Bob. So I'm a Senior Vice President in our Tax and Accounting division here at Wolters Kluwer, leading our U.S. professional business. And really what that means is we serve professional tax and audit firms from a sole proprietor right up to the Big Four so that they can complete their audit and tax workflows.
Thank you, Kathy. And Ross Aronowitz, am I pronouncing that right? Or?
You are. Hi, Bob. Thanks for having us. So I lead the law firm segment within our CT Corporation business. CT Corp is the largest provider of registered agent services, corporate compliance services. So we help companies form, help them stay compliant with the government, help them expand into other states.
Well, our topic today are these new beneficial reporting requirements that came into effect this year. I realize the law enacting them was actually passed a few years ago, but the requirements, as I understand it, are coming into effect this year. And what I wondered if we could start with is just kind of outlining more what this is all about. What are these requirements? What do they require of businesses? Who's best to kick that off of this group here?
Sure, I can take that. So, the Corporate Transparency Act is probably the most significant piece of federal legislation affecting business in over 100 years, basically since the U.S. security laws were enacted in the 1930s. As you mentioned, the law went into effect in January, and it represents a major shift in how companies are viewed by the federal government. So in order to curtail bad actors from using corporate structures, shell companies, for illegal acts, money laundering, financing of terrorism, tax fraud, the Congress passed the CTA that requires nearly all small businesses to file with the federal government, specifically FinCEN, which is a department of the Treasury, and identify details about the beneficial owners of their company. So with this law, no longer can companies just be formed as shell companies with no knowledge of, by the government of who owns it. And this is really catch up, I would say. Almost every developed country, most of Europe, Canada, they all have laws that are similar to this. So this is really the U.S. ensuring that, we have the same sort of transparency laws that other countries have.
Ken or Kathy, do you want to add anything to that in terms of the importance of this law?
I think that Ross really got it right in terms of the importance of it. That's absolutely new and important, but there's a lot of awareness that is still needing to be there around the law within our professional accounting firms. As an example, there's very little awareness with the firms as well as within their client base in terms of what the law means and what is the impact to their client base. So there's definitely a lot of education needed.
Yeah. And what exactly are we talking about here? I mean, what is beneficial ownership? What does it mean? And what businesses does this apply to?
Yeah, so a beneficial owner is defined as any individual who directly or indirectly exercises substantial control, that's the term, over a reporting company, or owns or controls at least 25% of the reporting company. So, so it includes owners, but it also can include, people in senior positions, people who have authority over the appointment or removal of any senior officer. So that's kind of how they define who is a beneficial owner.
What are the obstacles or what are the difficulties for companies in complying with this law? What are some of the issues they face in trying to understand and comply with it? I'm throwing it out there generally because I'm not sure which of you is the best to answer that question. But.
So the challenge to compliance is a lot more complex than at first blush. When you say, hey, you just need to report who is a beneficial owner to a federal government, it sounds like, okay, this is just a filing. But really, it requires collecting, what is personal identifiable information across what could be a large number of beneficial owners. So one company may have multiple beneficial owners, and you need to collect personal information, including passport or driver's license images across many, multiple beneficial owners. And then you need to ensure that all of the information is complete and accurate. And you need to ensure that you stay up to date, which is also complex. So anytime a beneficial owner moves, anytime a passport changes, anytime, any sort of personal information, they get married, their last name changes, that reporting company needs to make an update, an amendment to the filing. So this ends up being a larger obligation than you would first suspect, because it requires collecting information from multiple parties. It requires staying up to date. It requires handling very sensitive information. And so this is both an initial obligation, but really an ongoing obligation. And if you are a small business, that could be quite easy. But if you are a family office that has, multiple entities that might fall under this rule, it adds to the complexity. If you're a private equity firm with multiple entities that fall under this, if you're an advisor doing this on behalf of someone else, you need to collect this sensitive information. So again, the complexity starts increasing once you kind of fully understand all of the players and all of the requirements.
Yeah, I was just going to underscore a few things that you touched on, Ross, and that's the security. And, after we get through the awareness challenge of people even understanding if they're impacted by that. So I think that is challenge one. The second is making sure whoever is helping them with this filing, that they can actually trust them, because you are providing whoever's helping you with this service an incredible amount of sensitive data. And how is that data going to be stored for when there are changes, and making sure that you're compliant when there's changes? And there's going to be a really short time window when you file and then there's changes. And the change can be really simple. It can be, I moved, and then you have to file an update. So I think those are definitely some of the challenges, and making sure you have a provider that you really trust in terms of taking care of that secure data, as well as being able to help you when you have changes and in a timely way.
And by provider, are you talking about a technology provider, or are you talking about the service provider, be it a law firm or an accounting firm or whatever else?
Both, really. So when a small business entity makes, they need to make a filing, they look to one of two places, to a law firm or to their CPA. To get this type of guidance and this type of service. So for sure, they will want to be able to trust one of those two people. Second, however, though, is of that firm, when they choose a technology provider to help them provide the service, they absolutely need to look to the technology vendors that can give them the ability to handle the complexities in terms of storing this confidential data, as well as managing the complex multiple filings when you want to file and have those same information persist across multiple entities, as Ross was alluding to.
I would just add to this that this is a very pervasive issue for customers to comply and for companies to comply. There are nearly 33 million companies that the government estimates are going to be subject to this filing requirement in the first year, another 5 million each year after, and nearly 15 million updates are expected across the reporting required companies. So there's a lot that is going to affect a lot of people. And this is going to be something that I think is going to be different depending on the size of the company, the industry, the type of organization. So you might find that a smaller organization entity that relies more on their trusted accounting professionals is going to go there. You might find that there are mid-sized companies that, will rely on, a law firm to do these things. And then larger corporations aren't necessarily exempt from this because they have to go through perhaps thousands of legal entities and make sure that all of them are either exempt, or the handful that are necessary to comply are identified and those filings happen. So I think it's going to be very interesting to see how this plays out, because it's such a pervasive issue.
When you say the larger corporations go through legal, you mean talk about the legal entities that are owned under their umbrella corporation or something?
Yes.
Yeah.
Yes.
So, I know that you all are developing or have developed products that are responsive to this need, and each probably coming at this from a slightly different direction and with different sets of tools. So maybe we could talk a little bit about that and about some of what Wolters Kluwer is doing and developing to help businesses and the service providers for those businesses comply with this requirement. Ken, do you want to start talking about what Legisway is doing and what you're doing there?
Yeah, so WK has really taken a cross-company approach in solving this problem. I realized early on that we are uniquely positioned to help companies and their advisors solve this. So we touch on, many companies that are going to be directly affected, and we also have interactions with legal advisors, with accounting firms that will be helping their companies stay compliant. So we realized that we would have to create kind of a tool that could be used across Wolters Kluwer. So we developed a beneficial ownership platform, and it's really fit for what I would say several purposes, for many purposes. If you are a small business, it provides a secure, streamlined, intuitive process to simplify the filing process, reduce risk of errors. For larger companies, family offices, PE firms that have many entities, it allows users to bulk upload, bulk edit, draft amendments off of their existing filings. You can also send secure links to the beneficial owners so that they can upload information in a secure way. And for advisors, so law firms, accounting firms, it also helps you work with your client to provide that information, again, through a secure link. So, as I mentioned, I work within CT Corp. We help companies stay compliant every day. We help companies file with the government, whether it be their general entity filings or business licensing filings. So it's quite natural to then offer this other solution, which helps them stay compliant for this requirement.
Well, this may be a stupid question, but do the companies that come under this law necessarily even know who their beneficial owners are? Or are you able to help them in any way identify that?
So they sometimes know who their beneficial owners, but to your point, they may not always know, right? And so, we can provide general guidance of what the law says, but we urge them to reach out to their, legal advisor to get better information around who would qualify as a beneficial owner.
Again, just to build on that, Bob, to your prior question was, what are we doing as an organization to provide these services? So Rod's touched on having a platform within one division. Within our tax and accounting division, we've extended the beneficial ownership solution to be part of our professional platform that is used by tax professionals, and that is called CCH Access Beneficial Ownership. And so it's the same platform that we provide our tax solutions, provide our firm management solutions to help manage the firm. So in terms of your last question of how do we even know who the beneficial owners are, by having it integrated in with tax returns, we will be able to surface up diagnostics that say, hey, we can tell based on the tax return that you may need to file a beneficial ownership. So we today already have informational diagnostics to help that tax professional identify the people who need to file if they haven't already identified them.
So these platforms can help these professionals, or help rather these businesses, both manage the collection and the reporting of the data they need to comply with this law, but also then provide some analytics to help them evaluate whether in fact they are properly complying with the law. Is that fair to say?
Exactly. That's the beauty of having the diagnostic coming out of the tax solution to help the professional. But yeah, exactly. On the platform, you're able to have your full dashboard of who you filed for, being able to manage data across multiple entities, and it persists that data in a secure way so that when there are changes, you can make changes with just a few clicks. And then using our API integrations, we're able to get that information filed.
And then Ken, now back to you.
I would just add, in the law department, where an organization may have different ways of storing and collecting information, Legisway is an all-in-one legal product that allows you to store all your information in one place. For customers that choose to do that, Legisway does have the ability to help store all that information, create reports off of that, and then easily export that information into the filing platform or into the filing services. So that's definitely something that we see in terms of another place. I think all of this kind of comes down to we're very pervasive too in terms of the way we operate as Wolters Kluwer in this space, and therefore we're able to kind of touch in different ways for all the different unique needs that may be necessary for an individual organization to comply.
We have on this call three people representing three different divisions or components or segments of Wolters Kluwer. Is it how common or uncommon is it for you to be kind of taking a problem such as the beneficial ownership law and cross developing, I guess, around coming up with a way of addressing it?
I would say this is fairly a unique instance where I'll let Ross and Ken opine on it, but it's unique in that we have something that can span so many divisions. We also have another division called Corporate Performance and ESG, and that's a division that supports corporations. So within tax and accounting, we do have tax solutions and audit solutions that are used in that division, and even beneficial ownership can be leveraged by that division as well. So even extending this even further.
Yeah, I would agree that this is a bit unique. I think that speaks to how pervasive this requirement is. The fact that, as Ken mentioned, it touches on 32.6 million entities. And if you multiply that by the number of beneficial owners within each entity, you start getting to a meaningful percentage of all Americans that are almost going to be touched by this law. And so, just given how pervasive it is, this presented a unique opportunity to solve it across our divisions.
Although the beneficial ownership rule impacts more than 32 million small businesses throughout the United States, many of those businesses are unaware of it. In a recent survey by the National Small Business Association, 47% of business owners had never heard of the Corporate Transparency Act, and another 25% had heard of it but didn't know if it applied to them. When we return, I'll ask our guests about what Wolters Kluwer is doing to help raise awareness of this law and educate companies about its requirements. But first, please take this opportunity to learn about the generous sponsors who support this podcast. Looking for a practice management platform that can help you manage, automate, and scale your firm? Look no further than Practice Panther, the top-rated solution trusted by tens of thousands of lawyers. Practice Panther offers a range of native features to streamline your workflows, including time tracking, document sharing for e-signatures, business text messaging, and online payment processing, all accessible from a single platform. Discover how Practice Panther can help you take your practice to the next level by visiting practicepanther.com. Welcome back to Law Next. We're talking about the new beneficial ownership reporting requirements that took effect this year for millions of small businesses in the United States, and how legal tech can help those businesses and their legal and financial advisors understand and comply with the law. My guests today, all from Wolters Kluwer, are Ross Aronowitz, Vice President, Law Firm Segment Leader at CT Corporation, Ken Crutchfield, Vice President and General Manager of Legal Markets at Wolters Kluwer Legal and Regulatory US, and Kathy Rowe, Senior Vice President and Segment Leader, U.S. Professional Market Tax and Accounting, North America. Several surveys, including one by Wolters Kluwer itself, have found that many of the businesses impacted by the law are unaware of it altogether or unsure if it applies to them. As we return to our conversation, I ask our guests how Wolters Kluwer is helping raise awareness of the law and understanding of its requirements. Let's get back to that. Kathy, you talked earlier about the idea that it was one of the challenges in this law is simply raising awareness about the requirements. In what ways, if any, is Wolters Kluwer helping to make that happen, helping to raise awareness around what the requirements here are and what the law requires?
Yeah. Go ahead, Ken.
I think one thing that may not be readily known is that Vital Law, our legal and regulatory platform, tracks and monitors federal legislation and allows you to actually be aware of these sorts of things very early on. And then when they become something that is enacted law, it is easy to then know when does that become effective and be able to track those things. So that's something that I think is kind of in the DNA of Wolters Kluwer across all of our divisions, is this regulatory compliance theme and being able to keep track of law. So I think that's one part that I would just highlight. And then, more broadly, I'll let Ross, you or Kathy kind of share a little bit in terms of how we make people aware specifically to this.
Yeah, I from a tax and accounting standpoint, we had our user conference last fall where we have about 1,200 professional accounting firms come and join us for our annual event. And I asked for a show of hands to see how many people knew about this upcoming requirement to file in just 6 weeks after. And almost every hand shot up that they had no idea what I was talking about. So it quickly became the most popular topic at our user conference in late October. For our customers. So it really started there in terms of deep market awareness. We do all the classic ways of helping. We do a series of webinars. We partnered with different associations to, for example, we've invited the AICPA into some of our webinars so that they can help champion the message. We do a lot of different marketing campaigns and thought leadership. As well, we have some in-app ways of being able to educate our customers. I mentioned that diagnostic in our tax solution. That is another way where we have all of our tax professionals will get that informational diagnostic, and with just a click of a button, they're able to go out to our marketing page to get more information and watch different videos and just take a very simple survey to see if they're impacted or if their clients are impacted.
Yeah.
Ross, anything to add to that?
Similar for CT Corporation, as I mentioned, we are the largest provider of registered agent and corporate compliance services. So we have a broad reach of companies that are affected by this law. And similar to Kathy, when we've reached out to our customers and asked them, hey, have you heard of this law? We've gotten, very low reactions, very low response rates of, have you heard of it? And then for the ones who did hear, even lower that they were prepared, right? So this is the biggest law and change that is going to be affecting our customers that they haven't heard of and are not aware of. So we've been leveraging our scale, our go-to-market, touching our customers to ensure that they are knowledgeable about this act, but also hosting webinars to inform them of how they can be compliant. And consistently reaching out to ensure that they are aware and that they know how to comply.
Mm-hmm. The Ross and Kathy, you both mentioned the fact that this kind of reporting involves some very sensitive information on the part of the companies and the owners in terms of what has to be collected and compiled. So insofar as you have built a platform to help them do that, what guardrails do you have built into that platform to ensure that sensitive information is protected and secure?
I guess maybe for your audience, Bob, they may not be aware of some of the things that we do as Wolters Kluwer. So within the tax and accounting business, we file millions or maybe tens of billions of tax returns for corporations and for individuals. And that has an utmost security requirement in terms of how that goes. And there's scale and technology that gets leveraged there. And then similarly within the CT world, being the market leader in terms of corporate secretarial filings and other information like that, there are platforms that we have and technology that is industrial strength, strong and secure. And I don't know if that's generally understood when people think of Wolters Kluwer in the legal market or an attorney does, but just connecting those dots I think is very important.
What about I don't know. I mean, as I understand it, the Corporate Transparency Act, I think, was actually enacted in 2021 with the mandate that this law take effect this year. So I don't have any sense or understanding of how the law is likely to evolve or change, but I'm assuming there will be changes going forward, especially as it begins to be implemented and companies begin to work with it, and perhaps the strengths and weaknesses of the current scheme come to be better understood. So, what in terms of the platform that you've built, the tracking that you've built, I'm assuming there's some element in there of helping users keep up to date if there are those kinds of changes or developments.
Yeah, I would say one key aspect of it is, this requirement is at the federal level, right? Again, it's the first time the federal government is asking for this amount of information about, all of these small businesses. But in addition, states are now considering similar laws. So we've seen New York pass the exact same law with some minor tweaks, but generally the exact same law at the beginning of this year to go effect, I believe, the beginning of next year. And so a reporting company that is in New York will now need to file with both the federal and with the state the same report or similar report. And other states are considering similar updates. So to your point, Bob, this platform is nimble enough to adapt for that, right? So we will ensure that for those who file with the federal government can then send their report to New York State, and then as other jurisdictions adopt the law, we can allow for that.
Is that like like the privacy laws that are springing up all across the country? We're going to start to get state by state variations on these laws and on what's required and what has to be reported. Is that likely to be the scenario?
I think that's likely. Yes.
Scary thought. It's very similar to the tax return process where we submit to both as well. So our systems are already set up and able to handle the different filings.
Yeah, scary stuff. Well, scary to me. Anyway, I'm not in this space. What about the as the platform develops in terms of built-in sort of educational tools and whatever else to help people understand more about this law and help them understand exactly what their responsibilities are and how to comply with it?
Yeah, that's a great question. So as we launch new software in the cloud and browser-based solutions on our platform, we not only use modern UI, but we use a modern way to help with the ease of onboarding and education. So part of that, we use a technique called micro-learning, and it's really just when there's updates, you'll see little 2-minute videos, there's new features, click on it, you can see little videos to help you understand those features and enhancements. So that is the approach that we've taken with the platform, is to have this micro-learning there at the user's fingertips so that they know exactly what they need to do, and they don't need to take any kind of other types of training necessarily.
Yeah, we've released, a number of thought leadership, as I mentioned, webinars to inform people of the law. And we also have a wizard online that users can take and see whether they might be eligible and need to file for the report.
Mm-hmm. Are the beneficial ownership platform that you launched and the Access beneficial ownership platform that you launched, are they essentially the same platform modified for different audiences, or are they completely separate platforms, or how does that work?
Okay, I'll take that one. The platform that we've launched, CCH Access Beneficial Ownership, that's for the same platform as CT Beneficial Ownership and the platform for law firms. So it is the same platform, but really plugged into the platform that's used by the professional. So really not a whole lot of differences.
All right. So, but it is integrated then with the platform that they're already using, and they're able to work with it from there.
That's absolutely correct.
Okay. And then is there any cross-integration? Would there be any need for a cross-integration to the Legisway features that you're offering, Ken, or is that they don't fit together at all?
Not at this time. If we get enough customer demand and interest that we would do that, we would certainly do that. But at this point, being able to just export the information and then import it into the tool is sufficient at this point.
So, what do you think this looks like going forward? I mean, what is the deadline for companies to comply, and are you seeing pickup and traction, and what's happening in that sense?
Yes. So any company that existed prior to January 1st, 2024 has 1 year to comply. So the end of this year in order to file. But any new entities that get created this year have 90 days. So any new entities have a rolling 90 days to comply. And so that deadline is approaching quite quickly, right? At the end of March, that we'll start on a rolling basis hitting deadlines for any new entities that were created this year. And what I would say is, prior to the enactment of this law, I think there was a lot of denial that this is real. I think there was, people didn't understand both the scope and the requirement, and that this would actually take place and that they would actually be able to make this filing, required to make this filing. That's kind of what we heard from a lot of our law firm customers. Certainly, this can't be real. But, I think as the law actually went into effect, and then as all of the requirements by FinCEN actually happened and they were up and running on January 1st, and then they were accepting the report, I think it became realer. So that's basically what we've seen from our customers, a realization that this is real and that they need to comply. And we've seen their interactions with us continue to increase, and their and the volumes start to increase.
And is the customer's concern the scope of it, the granularity of it, or even just the mere requirement of it? What's the hardest part for them in terms of complying with this law?
I think it's all of the above. Yeah, it's the scope, it's the ongoing compliance, it's the personal identifiable information that they need to collect, right? I mean, especially for companies that have multiple entities or beneficial owners that, whose information may be changing over time, the requirement is quite vast. And so I think it's all of everything you just described that overwhelms some people.
And I think the penalties are also potentially overwhelming. It's more than $500 a day. There's prison terms thrown in there. So I think with the complexity of the filing for some entities, as well as when there's changes and making sure that you're filing on time, you want to make sure that you're getting it right.
Prison terms for negligent reporting or for fraudulent reporting? How does that work?
If you're not filing properly, I don't know, Ross or Ken,
Severe.
if you have more insights on when you're going to prison for this, but that is one of the penalties.
Yeah, the idea is that there would be heavy civil and criminal penalties for purposeful neglect of this law, purposefully not filing or making, or filing incorrect information. So, the idea is not to penalize people who generally didn't know or were trying to be good actors. But, the stiff penalties are in line with the reason that this law exists in the first place. Again, it's to curb shell companies, curb illicit acts, curb money laundering. And so to ensure that that's the case, there's, penalties that align to that.
I've seen some tools out there that are kind of basically self-help tools for companies to figure out whether they need to comply with this law. I'm wondering if you have thoughts on whether that is any substitute for the advice of a lawyer or an accountant in this situation. I mean, is it a simple calculation for a company to figure that out as a self-help tool likely to be reliable, or is this the kind of thing where they're going to need to be consulting with a professional in this area and get good advice on it?
So similarly, we offer a wizard that can help customers guide them through whether they need to comply with this law. But certainly if, there's uncertainty that they have, or if they don't understand some of the nuances of some of the questions, they should reach out to a legal advisor. This is not supposed to replace kind of, legal advice of, who should comply with a, regulatory requirement.
Certainly, you're going to have some organizations that are going to want to do it themselves no matter what. I mean, you see that with tax returns. I mean, some people do their own taxes that probably shouldn't. And there are some people that are very capable and able to do their own returns. But from a convenience perspective, or because of the complexity of the situation, many people go and rely on somebody that they can trust to be able to do that on their behalf. And I think this is the same sort of thing here. I could just imagine somebody trying to go to a beneficial owner of a corporation or an entity and trying to say, hey, I need your driver's license. That conversation, I'm sure, is going to happen over and over again with different people trying to understand what's going on. And, that might be better handled with an advisor that can help guide you on in terms of how just even to do the soft processes of communicating and explaining why this information is required.
I've been asking you lots of questions, and we're running low on time. And what I'd like to do is just kind of go around real quick and just see with each of you if there's anything further that you'd like to say about either what you're doing at Wolters Kluwer or about this law in general. Ken, can I start with you? Anything else you want to add?
Well, I just think this is an exciting topic and an exciting opportunity for Wolters Kluwer. It is going to be something that's going to be a significant challenge that's probably underestimated in the marketplace and has a lot of tentacles that maybe aren't noticeable on the surface. So this is going to be something that I think, we look forward to being able to serve the market and the various advisors that are involved in helping with compliance.
Kathy, how about you? All right, Ross, you get the last word.
Thanks, Bob. I would just reiterate everything we said. I recognize this can feel perhaps quite overwhelming, right? Both the stiff penalties as well as the complexity of the law. I think, step one is understanding that this law exists. So good news if you're listening that, you now understand that it exists. And then, as far as being compliant, step two is understanding whether you are affected by this law, either leveraging a BOI wizard that we have or contacting an advisor to understand if you are affected. And then step three is ensuring that you're compliant. And, as we mentioned, we have a tool that can help support you regardless of your type of situation, whether you're a small business with very simple needs and just needs a tool that can file, whether you're a large operating company with many entities that need to file, whether you're an advisor that needs a secure platform to interact with your clients. So, we have fit for multiple purposes, a tool that can help you stay compliant, regardless of kind of the complexity that you have.
Well, thank you all for being with me today to talk about this and for the work that you're all doing to help the business community and the legal and accounting communities at large make it through this new requirement. Appreciate your time and your insights on this.
Thank you.
Thank you.
Thanks to Ross Aronowitz, Ken Crutchfield, and Kathy Rowe for taking the time to join me today. I greatly appreciate their time and insights. I hope you enjoyed the conversation. If you'd like to share your own thoughts or comments on today's show, you can tweet us at LawNextPodcast or email me directly, ambrogi@gmail.com. If you're a fan of this podcast, please leave us a review wherever you get your podcasts. LawNext is a production of LawNext Media. I'm your host, Bob Ambrogi. I hope you'll join us again next time for another episode of Law Next.